Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the losses of Rajiv Khanna PC. This is a community conference call which we host every other Thursday, and we try to share whatever we do know with the community based upon your questions and discussions with you. At the very outset, I want to point out there are a couple of questions today that I have no knowledge of because these are very specific questions. There's a couple of questions from somebody from Canada, which deal with citizenship through grandfather, grandparents. No idea. I have to look at the law. I have to review the case law. I would not be able to answer those questions without some detailed study on this issue. So sorry, can't help you. But I'll try to guide you when I come to those questions, at least to the extent that I can, on how you can get reliable information. Okay, so let's begin. This time, I did not mark any question as a frequently asked question. These are all routine questions. Let's begin with Himani Patel. She's on a student visa and she is a derivative beneficiary in a family-based green card, which her US citizen aunt filed for mom, and the priority date is back in September 2004. Mom also has a B2 visa. What I'm understanding, Himani, if you are on the phone, we'll talk with you. But what I'm understanding you to say is that your mother is outside USA, you are inside USA. When can you file your 485? And I've never really run into the situation before where the principal beneficiary of a relative-based petition is outside the United States and the derivative of the beneficiary, which is you, is inside the USA. My guess is, this is my guess, either you should go for consular processing with the whole family, or I think you will have to wait until they get their green card approval through the consular processing and then apply for your adjustment of status in the United States. This is a guess. But to make things simple, you may want to just go and appear for visa stamping with your family, green card stamping with your family. The problem is if your mother comes to USA on a B2 visa and then applies for um, an adjustment of status to green card, that could be considered to be a fraudulent misuse of tourist visa. Not a good idea. Okay. Uh, Anybody has a question on this, press star 5. Press star 5 on your phone. Okay, no question on this. Let's go on to the next one. Uh, Here the problem is we have H1, H4 is in between extensions, and we don't have um, a driver's license. Well, this is a known issue and a known problem. Interestingly, under US immigration laws, you are not out of status when you have timely applied for a H1 extension. But state laws, which is what governs driver's licenses, has not kept up with that. So many times you end up in a situation where under federal law you're okay, but the state law is not permitting you to get a driver's license. It's really a state law issue. There's not much we can do. Um, and I think that beginning May 10th, the premium processing process should also be streamlined and on track. So not much I can tell you how to get your driver's license. You can try, if you will, um, and see if a state senator or a state legislator, remember, not federal, but if you are, let's say, if you are in Maryland, the Maryland state senator uh, can help you resolve this issue. It is unlikely, but it doesn't hurt to ask. Okay, so you can ask your local state representatives help to see if they can resolve the issue of driver's license for you, because technically when you have an extension pending, you're not out of status, you're not illegal. Okay, star 5 if you have a follow-up question on driver's license issue. Star 5. Okay, let's go on to the next one. Kintel says, currently I'm on H1, which is good till June 20th, and I-140 is approved. extension of the H1 has been filed. Now I'm getting a job offer from company B. Number one, should there be a waiting period after I-140 approval and before changing employer? Well, under the current law, there is none. But if your old employer revokes your I-140, USCIS, although they have flip-flopped on this issue a few times, has said that their most recent statement, oral statement, nothing written, was that even if the I-140 is revoked, unless it is revoked for fraud or misrepresentation, we will let you keep your priority date. But you will lose the right to get further H1 extensions because the I-140 will be gone. Okay, so you won't be able to get any extensions more than what you already have after you've got the extension for the new employer. So if the old employer doesn't revoke the I-140, then of course things are a lot simpler. Now, there are proposed regulations which are still pending. Those regulations have gone through what is called notice and comment. They were proposed, published, people commented on them. USCIS is considering them. Under the proposed regulations, from what I recall, the reg said, look, if your I-140 is approved and it stays unrevoked for 180 days, then not only for sure in writing, you definitely carry your priority date forever, you also have the right to keep extending your H1s forever. So under the current law, there is no layoff or cooling off period. Under new law which may come into being, waiting another 180 days after the approval could be very beneficial. Okay. Question number 2 was, if new company initiates transfer before June 20th, but joining is in July, as transfer will still be in progress, will it be an issue for H1 transfer approval, or should I wait till the H1 transfer is approved? Look, this is the way I see it. Because this is a rather precarious situation to be in, I would not want to kind of just completely jump boats. I would rather make sure that the second boat is firmly in place before I jump over. So I want you to, in my view, wait for the H1 transfer approval. Once it's completely approved, only then you should join. Follow-up questions on this issue, star 5. Press star 5 if you have a follow-up question on this issue. No new questions, please. Okay. This question I'm not going to be able to answer as far as the US citizenship of the child is concerned. I have to review the law. I'm sorry. This is these laws are so laws about citizenship become quite esoteric, very complicated. Not so much in concept as in variations. There are so many variations. I would have to read up on it. I don't know what the details are. Your research appears to be quite thorough. My recommendation would be go through your congressman's office, pose this question to them in writing. They'll be able to help you find the answers as well as I can. Okay. Second question, can a conditional green card holder travel abroad? Yes. A conditional green card is just the same as a regular green card. Whatever law applies to the regular green card holder, same law applies to a conditional green card holder as far as maintaining the green card is concerned. You have to have your permanent home in the US. Okay. You said, what is the upper limit? We have many frequently asked questions on this issue. Actually, I have asked my team to do a little bit better classification of the frequently asked questions. Right now, we have a lot of information, but it's not very nicely organized. They're working on it, but we've written on this issue in quite some detail. Okay, a green card holder is required to have their permanent home in the United States. If you are gone too long, even if you're gone for 2 days with the intention not to return, government can take away your green card. Okay, but normal procedure is if you are gone for less than 6 months, they don't ask too many questions. But if you do it repeatedly, they will ask questions. And if you are gone for more than 6 months, you'll be questioned very closely. If you are gone for a year or more, you will lose your green card. Okay, look into getting a re-entry permit, by the way. See if the re-entry permit applies to you. Okay. Any follow-up questions? Samir, if you're on the phone, any follow-up questions on this? *5. Okay, no follow-up questions. Let's go on to the next one. Sriram says, LCA violation back pay. So if the employer has not paid me, how can I get my back pay from the employer? There is a raised hand. Let me just get that first. 1 second. Yes, North Carolina, go ahead. I'm sorry, not North. Texas, go ahead,
Hello,
please. Yes, sir.
Hello.
Yes, sir. I can hear you.
Yeah, Rajiv, this is Samir. I'm calling in regards to question number 5.
About the citizenship, right? I told you that citizenship I can't really say.
Yeah. I have a question regarding question number 3. Can a conditional green card holder
Oh, I'm
sponsor
sorry. I'm
experience
sorry.
for
I'm
related?
sorry. I'm sorry. Yeah, yeah. I kind of skipped that. No, no. Of course. Like I said, your green card is as good as anybody else's. Whatever another green card holder can do, you can as well. So, can you sponsor your parents for a visitor visa? Yes, you can. Now, remember, for a visitor visa, there is no specific format for what you need to do. Normally, what people do is they just provide something called Form I-134. I-134 called Affidavit of Support. Don't confuse that with I-864. That's a different affidavit of support used for green card. When you get somebody here on a tourist visa or student visa, you fill Form I-134. You don't have to, but you can if you want.
Sorry, you mentioned I-134.
Correct.
Okay, and one more addition. Okay,
Yes.
okay.
Go
Thanks,
ahead.
Rajiv. One more additional question regards to the same. Can a conditional green card holder be eligible to file for unemployment benefits?
For what benefits?
Unemployment.
Oh, yes. Oh, yes. Actually, it's interesting. You asked that question. Just 2 minutes ago, I tweeted this. If you look at my tweets, just 2 minutes ago, I tweeted on this issue. Who, give me 1 second. I'm confirming that for you.
The reason I'm asking you this question is that my contract ended like 3 days back. So,
Yeah. No, there's no problem because unemployment is not a means tested benefit. So if you go to my tweets, my last tweet is about tips for passwords and how to secure your passwords. But the one before that says public charge, immigration consequences of receiving benefits assistance. If you click on that link, it tells you unemployment is no problem.
Okay.
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 Anything else?
Not really, sir. Thank you. Yeah.
Oh, you're welcome. Good luck, sir.
Thank you.
Okay. So let's go on to the next question. LCA violation. So if the employer is not paying or underpaying for 6 months, should I go file a complaint with the Department of Labor or contact an attorney? You should definitely file a complaint. Okay, because contacting a lawyer, in my view, is a waste of money. Something like this, when the government is there to recover the money from you, and they do a much more effective job than any lawyer can do, in my opinion. If there's an LCI violation, government will step in and get your money for you. So go to the wage and hour division. Wage and hour division. I think their form is called WH4 or WD4, one of these forms. I think it's WH4. So just fill out that form and get that process started. *5 if you have a question. *5, follow-up questions on this. Okay, let's go. Samir, is that you again? Samir?
Hey, hello, Rajiv. Yes, sir. I just forgot to ask you about the unemployment benefit. In continuation to the same question, if, for example, I'm eligible, so at the time of at the time of me filing for removal of conditions at the end of the 2 year conditional green card, or at the time of filing for citizenship, will that be some kind of an issue or some kind of a problem?
No, because like I said, unemployment benefits are merely, they're the same as a private insurance. So let us say that you have homeowners insurance and somebody stole your laptop from your home, you can make a claim against it and get your money from the insurance company. It's the same thing for unemployment. Okay, so I don't see any problem there.
Okay.
All right. Good luck.
Thanks.
You're welcome. Okay, let's go to North Carolina. North Carolina, go ahead, please. North Carolina.
Hello, sir. I'm not actually from North Carolina. I don't know. Am I the person to answer?
Oh, that's no problem.
Question?
As long as your question is not a new question, but a follow-up on the LCA violation question, you're good to go. I don't care where you're from. Your caller ID says North Carolina.
Yeah, it is North Carolina number. That's true. Okay. My question is not related to this.
Okay, then hang on. Then you wait. Okay, wait till the end of the call. Okay. I'll call upon new questions. All right. Mohit Kapil says, I have come to USA on immigration, family-based immigration. Online fees was paid. My plastic green card has not been received over 50 days. Immigration was done at Abu Dhabi airport. I was traveling some airways. I want to go back to India for my marriage. Can I travel on I-551? It's a good question. You see, let us not confuse my legal right with my proof of legal right. Okay, give you an example. How having a green card status and having a proof of green card are two different things. Let's say you are married. Okay, that's your status. You're married. But to prove the marriage, you need a marriage certificate. So the marriage certificate is just the proof. That doesn't change the fact that you are married. Okay. In the same way, having that plastic green card is merely evidence of your status. It is not your status itself. Your status is a green card holder. The only question is, how do I prove it? And you prove it with a green card. Now, how do I travel? Well, what you do is you make an appointment, InfoPass appointment, with a local USCIS, InfoPass, INFOPASS. You make an InfoPass appointment and you ask them to stamp your passport for travel. Okay, so that stamp is usually good for between 1 and 2 years. There are some variations, but let's say you get it for 1 year. During that 1 year, that stamp is as good as a plastic green card. You can use it to travel, you can use it to work. Anything that somebody with a plastic green card can do, you can do as well. That's what I would recommend. And you already actually know it. You said, if I travel to India on I-551 stamp, which is what I'm talking about, will they send my green card to my mailing address? They will send it to you. Yes, they won't hold it back. In my absence, my family member receives the green card. Can they send it to me? Yes, they can. They can send it to you via courier, or you can just come back using your stamp. You're fine. How many days does USCIS take to send green card to my mailing address? Well, that's very difficult to predict. There are so many variations. Last I heard, most recently, they were sending them within a couple of weeks. So while it is unusual, it is not unheard of. All right, *5 if you have a follow-up question. No new questions yet? Follow up on this issue. *5. Okay. A Golbala says, B2 visa for parents who have an I-130 approved filed in 2003. Recently, they were denied B2 visa on grounds of immigration intent. Their B2 visa application stated they no longer wish to immigrate to USA and that they are fine with withdrawal of the I-130. So question number 1, can chances of getting B2 visa be approved by withdrawing the I-130? And the answer is maybe, because it all depends upon the consulate. See, this is a question of interpretation. Two people could look at the same act, which is withdrawal, and come to different conclusions. I'm not sure there's any particular law that covers this issue. In fact, I've never seen one. Common sense says, if you withdraw it, maybe it becomes easier. As a beneficiary, can they request voluntary withdrawal of the I-130 petition? Actually, there is no such provision. But writing to the government saying that I'm not interested could help. And if you do it under certified mail, you can take that letter and show it during the visa process that look, we are no longer interested in this process. So you can try. I'm not sure it's going to help, but definitely it wouldn't hurt. *5 if you have a follow-up question on this issue. *5 if you have a follow-up question. Okay, no follow-up question. Let's go on to ANC and C1. H1B. Current H1B was done, had H1B done by a company in 2008. Okay. I stayed in USA, worked for company A till 2009, moved back in mid 2009, never came, transferred from company A to company B last year and got the visa stamped in January 2016. I did not travel to USA on this visa yet. Now, the question is, I'm transferring again from B to C. Should I go for visa stamping again? I think you should. Okay. Normally, if you were in the US and you were working for company B, and while in the US, you transferred your H1 to company C, I probably would not tell you to go get your visa stamping done again. The consulate will say that you should, but I know that their own internal procedures say that in these situations, you should not have to stamp your visa again. Okay. But your situation is a little different. Your situation is you're outside USA, transferred to B, never worked for them, want to transfer to C. Should I go for visa stamping? And I think you should. Should I wait a few months? No, I think you should go as early as possible. One of my problems is when people wait too long, it makes me suspect whether there's really a job. Why are they waiting this long to stamp? What sort of documentation is recommended to carry for the visa? Well, first of all, remember, the consulate can ask you for anything. They're not bound by any particular numbers or documents that they can ask for. They can ask you for any document they like, but whatever they want as the very basis for your application should be on their website. So whichever consulate you're applying through, go to their website, see what documents they want you to bring. Okay. A copy of your petition is usually already with them because it's a part of the what is it called? PIMS, Personal Information Management System. So all consulates have access to your H1. Okay. *5 if you have a follow-up question on this. *5, no new questions, please. *5 for a follow-up question. Okay, no follow-up question. Let's go on to Aditya Gaitonde. Aditya says, urgent question related to my H1B. What happens if I get laid off? Aditya ji, I actually dug out my article. It's in the frequently asked questions on what to do when you get laid off. I think I need to probably improve the findability of this article. Maybe I'll just tweet it. That might be the easiest thing to do. Let me review this article. Make sure it's still recent because I'm looking at the article. It's good. It was written back in 2008. It has excellent information on layoffs. I've written on this issue many times and even spoken on it. I just don't know where everything is. We have to do a better job of cataloging our information, and we will. We are actually getting to that position. Let me tweet this for you. So just look at my tweets. Usually I have 4, 5, 6 tweets a day. Just follow my tweets, and it's immigration.com. My Twitter account is immigration.com. So I just have a few notifications. Okay, so yeah, just go to immigration.com. You can also immigration.com. That's my Twitter handle. You can go to immigration.com, and on the right-hand side, you will see that we have. I'm just showing you my Twitter feed on the screen. My Twitter feed is on the right-hand side of the screen also. You can just follow me from here if you like. Okay, so let's go on to Twitter. Where was I? Oh, yeah. Okay. So on the laid off issue, I want to post something. But are you on the phone? Press *5 if you're on the phone. *5. I'll give you a quick summary if you're here. Otherwise, just wait for my tweet or my blog entry to be updated. Okay, you are here. Let's just. Hi, you have a question about your H1 layoff, right?
Yeah, so I am on the call.
Okay, so let me give you a quick summary. Point number one: the day you get laid off, that is the day you are out of status as far as H1 is concerned. Okay, so if they say, okay, you are laid off, but you're going to get paid for 2 weeks, we can think that, okay, you are in status for 2 weeks. But there is no grace period under the current regulations for people who get laid off. Number one. Number two, how can I maintain legal status? I have advised people to file for a B1, B2 visa, request the government for a temporary status, explain to them that you have been laid off unexpectedly and that you're looking for another job. You write a cover letter saying that. Along with that, you file the form I-539 requesting B1, B2. Um, and basically, once you file it, it'll stay pending for 3, 4, 5, 6 months. Whether they give it to you or not, you are not out of status for the duration of the pendency. But it must be filed and received by USCIS before you're laid off. Now, I don't know whether they allow online filing of I-539s right now or not, but there was a period when they were doing that. So double check on USCIS website. If you can file it online, that's the best thing for you. Okay. Now,
So what?
I have one more
So
point.
what if
I have one more point to make.
Yeah, sorry.
Aditya ji.
Sorry.
The point is this. Now, let's say my B visa is pending. This is the difficult point. My B visa is pending. So I found another job. Okay. My new employer has applied for my H1. Remember, the day your H1 is decided, the new H1, if your B visa is not already approved, chances are USCIS will not give you H1 within USA. They'll give it to you, but then you have to go get your visa stamping done. Okay, that's the way it typically works. Now go ahead with your questions, please.
Yeah, so suppose I get a job in like a period of time. Where, when do I get into status? Whenever that has the request has been made, or when the visa is approved?
Actually, I think last week, I'm clicking on this. We did a very thorough analysis of the difference between, I'm trying to see, I think it's in the frequently asked questions. Definitely in the last community conference call or the one before that, we did a very thorough analysis of the difference between status, unlawful presence, and authorized period of stay. What is authorized period of stay? When your H1 has expired, but a timely filed extension application or B conversion application or H4 conversion application is still pending, you are not in full status, but you're authorized to stay. Okay? So if your application is timely filed, as long as it is pending, you are in authorized period of stay.
Okay.
Anything else?
I think that's it for now.
Very good. Good luck to you, sir.
Thank you.
All right. Let's go on to the next question. Parthasen Gupta says, two questions. I-140 approved March 2016, priority date is 2015. I've also got my 3 years of H1B extension good till 2019. What if I change my jobs before the 180 days? Well, right now there is no 180 days. Only the new regulations that are being proposed would give you some additional security after I-140 has been approved 180 days. Under the current thinking, whether you leave the day after the I-140 is approved or 3 years after the I-140 is approved, the level of your protection is the same. If I move temporarily to H4 under my spouse, is there any implication on my approved I-140? There is none. There is no implication if you decide to go from H1 to H4. That does not affect the I-140. Can I move back to H1B? Absolutely, you can. You would not be subject to the quota, and you can use the I-140 to extend H1 as long as the I-140 has not been revoked. You can use that to extend your H1 for the same employer or any other employer. *5 if you're not clear. *5. Any questions, follow-up questions on this issue? Nothing new, please. No new questions. *5 for follow-up questions. All right. STEM OPT. So the question is from Saji. My 12-month OPT is ending on June 28th. If my 2-year extension is not received by USCIS by May 10th, will this be a problem? I don't see why this should be a problem. Because, see, your deadline for getting the application to the USCIS is June 28th when your OPT is ending. May 10th is merely the period on which the new regulations start. So that's not your deadline. Your deadline is your 2-year extension must be received by the USCIS. That's the way I understand the law. You can confirm that with your DSO. They're fairly well trained on these issues. But my understanding is that as long as your 2-year request, STEM extension request is received by USCIS before June 28th, you're good. Okay, so your deadline is not May 10th, it's June 28th, actually 27th, let's say. *5 if you have a follow-up question on this. No new question. *5 for a follow-up question. Okay. SAN1236, long pattern, guys. Don't make these so long. Santosh says he's got a very long fact pattern. I'll try to parse through it. Usually we don't have that much time. So H1B visa stamped with a reputed company A, but have not traveled on H1 visa yet. Okay. Wife is currently working in USA on H1B. I also have a B1, B2 visa. I'm planning to quit A as I'm not getting US project. Three are the options that following three options I see. Which of the following three options would I recommend? Number 1, find a company or a consultancy in India who can do H1 to H1 premium transfer in India itself and then travel to USA on my new H1. 2, apply for H4 stamping, then travel, and then change status. 3, travel on B2. Absolutely, 3 is absolutely out. Between 1 and 2, I prefer 2. Come to USA on H4, and that way I think finding a job would be a little easier. And converting from H4 to H1 is not difficult. And you are not subject to the quota. Okay? That's what I would recommend. Some related queries are there any chances of rejection denial during H4 to H1 transfer because mine is an unused H1? No, I don't see why. You see, when you get a visa stamped, your USCIS thinking is that you're no longer subject to the quota, even if you've never worked for that employer in USA. 2, when I quit company A in India, they will revoke my H1 petition. See, any revocation after the quota has kicked in, I'm assuming that you're talking about, because I think you're covered by the old quota, which was back in 2015. So I don't see how the revocation affects you. You're already exempt from the quota. Okay. Can the new company file a cap exempt H1? Yes, anytime within 6 years of the last approval, you are cap exempt. Does my existing H1 get marked CWP or cancelled when I go for H4 stamping? It does not matter even if it does. I don't see how that affects you. Okay. Uh, Last one, does opting for H1 to H1 transfer via consultancy is safe or better to go via a reputed company? Look, Santoshi, I have never really worried about the reputation of a company. I am more concerned about their conduct, not their reputation. If a company is a good company, just because their reputation is good doesn't mean they're a good company. That's the paradox. Um, See, signs are they won't ask you to pay anything. If they ask you to pay something, run from them. Because any reputable company, more than reputable company with good conduct, recognizes the fact that they are not allowed to ask you for payments towards H1. These are some of the signs. Of course, you can do your homework, but that's the way I see it. Coming to H4, coming to USA on H4, then applying for H1 seems to be a better option. Star 5 if you have a follow-up question. No new questions. Follow-up question on this issue, star 5. Okay. Illinois.
Hi, Rajiv.
Yes, go ahead, please.
Hi, Rajiv. This is Deepa here. This is with regards to Santosh's question. So, what you are suggesting is better to go with H4 and then travel to US and then look for a job after coming here.
Yes, ma'am. That's what I think. It's not only legal; it's just common sense. Knowing what I know about the law. See, I'll give you an example, Deepaji. If you come on, first of all, H4 visa stamping is a lot easier than H1 visa stamping. Okay, so if he gets an H1 and then he has to go in for visa stamping again, who knows how long he will be stuck. So getting H4 visa stamping uh, is just easier. Number one. Number two, if he's in the USA, finding a good job is a much easier proposition because he can interview with the companies, he can talk to people, he can also investigate companies much more efficiently. That's what I think.
Okay, okay. One more thing, when he goes for H4 stamping, would they cancel his H1 or would it still be valid?
See, the thing is, why should that be relevant? I don't see why that is relevant. Now, technically, consulates are supposed to revoke all inconsistent visas, and they should revoke them. They should cancel it, but that's not a problem. I don't see it as an issue.
Okay, so what you're saying is even if the company withdraws the petition, even if his H1 is revoked, since it is a cap exempted petition, we can again get it extended once he finds a job after coming to US.
That is what I believe. Yes, ma'am. Okay.
Okay. Okay.
Good luck.
And
Yeah, make it quick. I have to go on to other questions. Ma'am?
Sorry.
Yeah, make it
You
quick.
wanted to say something?
Yeah, I said make it quick if you have a follow-up.
Yes, yeah. During once he finds a job after coming to US, how will the I-94 application would be taken care? Like he is entering in H4, but
don't worry about all these details. They're all taken care of as a part of the process. Okay, that's just logistics. Don't worry about it. That's not a difficult thing.
Okay.
All right.
Okay.
Good luck.
Okay. Yeah. Thanks. Thanks, Rajiv.
You're
Thank
welcome.
you.
You're welcome. Okay. This is the one, Bob. I don't know the answers to your questions. These are very, very specific questions. You have written a question about acquiring citizenship through a very specific process of which I have almost zero knowledge, the doctrine of double construction retention. No clue. Never looked into it, never had to. So unless I hit the books, and every time we hit the books, it costs you money. So what I would suggest is this. if you have family in the United States who can call their congressman's office and ask this question, a United States member of Congress, whether senator or House of Representative member, can find you this information and the answers pretty accurately, and it won't cost you anything. If you don't have any family in the USA who can do it for you, you can try contacting a congressman. Just pick any congressman and explain to them your situation. Typically, you will call them up. You go to congress.gov. There's a place where you can enter your zip code. If you're not living in USA, you can just pick any congressman at random and call their office and say that you want this information. If you want to reside in that area when you get your green card, if you get your naturalization, you can let them know that you are an intended constituent and can you please find this information for me. They'll have one or two staffers who are devoted to chasing down immigration information. They can find it for you. Okay. Not much I can say about this. I haven't really studied this issue. B. Narendra, approved I-140 from company A, moved to company B. Right now, labor got approved. I-140 is submitted, in progress with company B. If I want to move from H-1B to H-4 and come back to H-1B when the date becomes current, is this okay? Of course. Do I need to file again new labor in I-140? No, no. That's not how it works. First of all, you are entitled usually to get H1 extension beyond 6 years based upon the old I-140 if it is not yet revoked, even though you're working with a different company, or based upon 1-year anniversary of your new perm filing, or based upon I-140 approval through the current employer. Any one of those three, if they apply to you, you can get H1 extension. You don't even have to go back to H4. But if you do end up going to H4, and you can definitely come back to H1B anytime you like. I hope that explains it. Star 5 if you have a follow-up question. No new questions. Star 5 for a follow-up question. Okay. Ram_La says, just made aware of a situation about my H1B. With approved I-140 PD of June 2010, we are expecting another child. She's in the last trimester of her pregnancy. I was working for a long-term project at client A for about 2 years. They have a contract employee roll-off after 18 months. So there's a 90-day roll-off. I changed client and joined client B end of last year. I was supposed to rejoin client A after 90 days. My employer did not file H-1B amendment. Due to some unforeseen contract issue, I was not able to join client A. Now they are filing H-1B amendment for client B. What are the chances? We've gotten approvals where the error was inadvertent, it was just a mistake. But if this is a deliberate conduct of the employer, it really is a judgment call of the USCIS. Nobody can predict which way it's going to go. The good news is, usually, if somebody has an H4, like your wife has an H4, which is good, the I-94 is good, she doesn't accrue unlawful presence. Even though she falls out of status because you have fallen out of status, she doesn't accrue unlawful presence until her I-94 expires. So, but don't take my word for it. This is just a generic statement, something to look at. Get yourself, your lawyers should review your case and make sure that she's protected. So even if you had to travel, she could travel a little later. Okay. And of course, I have discussed today about filing for a B2. She could file a B1, B2 right now and get a few months, 4, 5, 6 months reprieve, and later on get another H4 filing done if necessary. Okay, so that's the way I would do it. I would either probably either do B1, B2 application for her, or file my own H1 amendment premium processing, see how that rolls through. And if it comes through fine, then of course there is no problem. But if it gets rejected and you have to go for visa stamping, keep in mind that she can go sometime later as long as her I-94 is not expired. She is not unlawfully present even though she's out of status. Discuss this with your lawyers in detail, okay? *5 if you have a follow-up question on this. No new question. *5 for a follow-up question. Okay. Calista came to USA on F2 visa, changed to H4, haven't gone home yet, want to travel, F2 expired 2 years ago. I'll need an H4 visa stamp. Now, husband's job is applying for a green card. Can I get a stamp? Yes, absolutely. You see, the good news is H4 visa stamping, you're going to Kenya, is usually pretty easy to get. Okay, usually. I mean, unless there's something wrong with the H1 or your own background, H4 visa stamping is one of the easiest ones to get. Okay. And the fact that your husband has applied for a green card has absolutely no negative effect on the H4 visa. Okay. So I wouldn't worry about that part. *5 if you have a follow-up question on this. Calista, if you are here. *5. Okay. Bob has this doctrine of a constructive retention question. Okay, there is a follow-up on the earlier question. Let's go to it. Richmond, Virginia. Go ahead, please. Virginia, go ahead.
Hello, this is Kalista.
Yes, ma'am, I can hear you. Go ahead.
I was just wondering, is there any, I was trying to check on the consulate, the embassy from my country. I'm from Kenya. I didn't find the documents needed, and I just don't want to go and have trouble coming back. I'm trying to know what kind of, documents that they may need for me to get the H4 stamping.
Okay, well, first of all, let's break this question up. First question is, can I apply from a third country other than my home country? The answer is sure. This is called TCN, Third Country National Processing. Isn't that what you asked me, ma'am?
Yes.
Okay, so you can apply from any country, and I actually recommend many people to, before you go for vacation, why don't you go to Canada and apply there, or Mexico? That way, you know you've got your visa and you are free to travel and you can come back, you can enjoy your vacation. So that's another thing you can do.
So it's the first time stamping. So can I go to any country like Canada and have it stamped and go back home with this, and I won't have to get to the embassy, which is my
Exactly.
embassy, saying?
Exactly. If you are one of the countries with which we have a treaty like Indians do, most countries do, where you get multiple entry visa stamping, the fact that you got it done from Canada, Mexico, Kenya, India, it doesn't matter. Once you get it stamped, it's a multiple entry document. You don't have to apply for it again, no matter how many times you use it. So it just makes your vacation a little easier, I think.
Okay, and I have one quick question.
Sure. No, but you had, ma'am, you had a second part of that question. Let me try to remember. I said, let's break that question down. One part of the question was applying from a third country. Second was, what document should I bring? It's better to just always go to the consulate website and see what documents they want you to bring. Okay?
Okay.
Go ahead if you have.
And, the other question is, I'm in the process of trying to find an employer to give me H1B, and I wanted to maybe, like I said, I wanted to travel this month. So if that could happen within that time, I'm wondering if that would create an issue. I traveled to go get something for H4, but I leave as a process to get the H1B, hopefully.
Well,
will that create an issue?
Well, you cannot travel while a change of status from H4 to H1 is pending. If you travel, then you are supposed to have abandoned that change of status, but you still get your H1, but then you have to go get your visa stamping done usually.
Okay. All right. I think I understand that.
Okay. All right.
Thank you very much.
Yeah, Santoshi, I got your tweet. Thank you. Nice.
What's that?
No, just somebody who was on the phone call sent a tweet to me. Just a thank you and and encouragement. Appreciate it. Okay, ma'am. Well, good luck to you.
Thank you very much.
You're welcome. Okay. So, funny, Churana says, I have a national interest waiver approved from company A. Then I lost my job. The company promised not to withdraw the I-140. Now I'm working for company B. Do I need to transfer my I-140? It depends upon the nature of the I-140. It's interesting. These issues have not really been settled very clearly. I'll give you an example. Let's say I get a national interest waiver based upon my job, which involved, I don't know, some defense issues. Okay. Let's say I made a database that defense uses 1,000 times faster because of my expertise in database development. Now I get an NIW, then I change my job and I become a Java programmer with a regular company. Can I carry my NIW over or do I have to do everything all over again? I don't know the answer to that question. I don't think anybody does. So what I would want you to do is, first, I want a lawyer to go over your national interest waiver case, see what was the basis of that. If the basis of that case are still true, and I'm here, I haven't studied this issue in detail, but this is my common sense answer. Have your I-140 looked at, have the petition looked at, make sure that the second job that you are doing, it is in line with the purposes of the I-140 that was approved. If indeed it is, then you have nothing to worry about. Okay. Now, one thing is for sure, unless that I-140 is revoked by USCIS, you should be able to carry the priority date. Okay. So if your lawyer says, look, this I-140 looks like it's not in line with your next job, let's start a new perm for you, you should do that. Okay. So can you file a 485? Well, if the NIW was based upon your expertise in general and not a very specific situation related to the job, I think so. Why not? Okay. But if it was very specific to the job that you were doing, then I think it should be very cautiously handled because we are now going into a gray area where nobody really knows the answers. Star 5 if you have a follow-up question. Star 5. No new questions. We are coming to the end of the calls. We'll start new questions soon. Okay. Jaybird, this is our second last question. Jay says, my perm was filed 2016. Based on some recent regulation changes related to job changes. There is no change right now. It is proposed. Okay. Can I carry my priority date and I-140 to my next employer job? And the answer is, if the I-140 is approved under the current thinking of USCIS, which is not written down anywhere, you should be able to carry your priority date even if the employer revokes your I-140. How long do I have to wait to change my jobs? There is no required period. Keep in mind, if you change your jobs and the I-140 is revoked, two things happen. You should be able to keep your priority date, but you will not be able to extend your H1 beyond the period already given. So you'll have to start a new green card. Okay. Can I ask new employer to continue the green card using the approved I-140? No. Not under the old regulations, not even under the proposed new regulations. Okay. Why are employers hesitant to file green card? They have to pay for it. I don't know. I mean, this is a difficult question to answer. Each case is different. Employers have to pay for it. It could require some amount of work on their part, but it's really not a difficult process. If the employer is motivated and they do it right, they do it by the book under the law, it should not be a problem. Based upon repeated query by other members on this thread, I'm curious to know why someone would try to change from H1B to H4 after having their I-140 approved. Is there an inherent advantage to this? Well, real quickly, one advantage of an H4 EAD is that you can do multiple jobs or work wherever you want because an EAD is open for any kind of employment if it is H4 derivative. Okay, so that's one advantage. I don't know why somebody would want to do it, but I can tell you the advantage of H4 EAD over H1, which is H4 EAD is open market employment. You can pretty much do what you want, work or not work. Okay, so what if somebody's not feeling well and they have to reduce their working hours? They'll have to do H1B amendment, or they can directly go for, let me check my tweets, I'm sorry. Or they can, okay, they can go directly for H4 and just, use their EAD whenever they feel like using. H1, you don't have such luxury. You have to go for an amendment. Okay. Follow-up questions, Jay, if you are here, *5. Follow-up questions. Okay, let's do the last question, then we'll start the new questions. This is from Chandra Yadavali. He says, I had an H1B stamp with company A, moved to company B. Company A revoked my visa. I'm planning to go to India. See, I have been using company stamping cannot be revoked. I don't think they can revoke your stamping. They can revoke your approval. My feeling, and I have, last time I checked, I would want you to double check with your lawyers. I feel that in your situation, you should not have to get another visa stamping done. Consulates say you do, but their own standard operating procedures, which is their foreign affairs manual, says that you don't have to. So I think you can use the same stamping. Have your lawyers double check it, please, but I don't see any problem with it. So your wife's H4 visa is still good. It doesn't require any transfer when you change employers. Okay, she for sure can use the same visa. That's an easy question. Okay, *5 for any follow-ups on this. *5. Okay, any question? Anyone, new question, old question? *5, please. Press *5. 1, 2, 3. Okay, 4. All right, 4, folks. 5. There are other people on the call. 6. Make sure you all raise your hands. I won't answer anything beyond these 6 questions then, folks. You sure nobody else has a question? 6 questions. All right, let's start. In the order that people logged in, whoever logged in first will take their question first. Let's go with North Carolina first. North Carolina, go ahead, please.
Yes, sir. My question is, my priority date was January 2007. I filed under EB3 in Texas. So now I wanted to move to EB2. So I got 140 approved in March 2016, EB2. But the old priority date was captured. So, and then my company lawyer wants to apply for fresh 485 under EB2. But I was thinking whether it is fast if I port from EB3 to EB2 versus applying a new 485 and wait for a long time.
Okay, you have hang on, sir. You have a 485 pending already under the EB3?
Yes, 485 pending on EB3.
Okay, was that I-140? Well, let me rephrase that. Okay, the answer is simple. I see absolutely no need to file a new I-485. No need to take more expense and more time. Just the new I-140 should be placed on top of the existing 485. Very simple process.
And he already filed EB2 485 in April.
Why?
So can I don't know, because he never consulted us. He simply asked us to go for the 485.
Okay, hang on 1 second. Has your filing fees check been cashed for the 485?
Yes.
Okay. See,
It
hang
took
on, hang on,
$1,075.
sir, this is what you should do. First of all, make sure that the A number used on both 485s is the same, so that there is no confusion, number one. Number two, contact the USCIS customer service and ask them which one do they recommend you withdraw, the old one or the new one. Okay, because my feeling is withdrawing the new one still may be faster. Okay, but the new one has the medicals, so those medicals are fresh. Maybe that is okay. So it's difficult for me to decide which one will go faster. Ask USCIS. If you don't want to withdraw either one of them, make sure that the A numbers are connected. You should be fine.
And there is not big time difference. Since my date is current, there is no big time difference for porting versus new one.
I do not know the answer to that question. That's why I said that's one issue I can't really talk about, because I don't know which one is going to go faster. It's such a difficult thing to say. On the one hand, when you have a 485 already pending, it has been processed to a certain stage. Maybe it'll go a little faster. On the other hand, maybe it'll go a little slower. I don't really know. Ask USCIS customer service. You may get a good answer, you may not get a good answer. In any case, I don't think the difference is going to be that big. Okay? Good luck, sir.
Thank you.
Oh, you're welcome.
Thank you.
All right, let's go to.
Hello?
Give me 1 second, sir. Give me 1 second. Okay. Massachusetts. Yeah, go ahead, sir. We can hear you.
Hello, sir. Yes. I filed my labor certificate, which was approved this week under EV2, and my H1B is expiring on September 31st this year, 2016. So I have less than 5 months. My attorney, my company is preparing to file I-140 and 485 concurrently. My question is, I heard that I-140 needs to be approved in order to get 485 process. So filing this concurrently to both 140 and 485, does that leave me enough time to continue my work after H1 expires? I think he's going to file EAD as well, along with all other applications. Is that all?
When does your H1 expire?
September 31st, 2016, this year.
When was your perm filed?
Perm was filed December 18, 2015.
Do you have any time to recapture when you traveled outside USA in the last 6 years?
No.
Okay.
No.
All right. This is what you should do. First of all, filing concurrently is standard operating procedure. Everybody files concurrently when the dates are current, and there is no requirement that the I-140 should be approved first. No requirement. Okay. Some forms you have to get them approved first. For example, investor visas, EB5, you've got to get the form approved first, then file 485. I-140s are different. You can file them concurrent. Okay. Number one. Number two, I think there's enough time here that you will get your EAD. Okay.
Sorry again. Did you say enough time or not enough time?
I think there's enough time.
Okay.
Okay. So all in all, I think
how does it work? Does the I-140 needs to be approved before 485 process, or when it says
No. What they are doing these days is this. This is my understanding. What they're doing is, when you file the I-140, 485, they start the processing of the EAD right away. It's not like they're going to wait for the I-140 to be approved, then process the EAD.
Okay.
Okay. But you know what you can do? Just to remove any element of doubt, just premium process your I-140.
Yes,
That's what I was thinking. That's my option. I asked the attorney and he yet to reply.
That's a smart option.
We can pay for premium process.
Right, and you can offer to pay for it, just premium it. That's the best thing to do. Okay. Another thing about, hang on. Let me explain to you why that is also better. In premium processing, definitely you will get approval or denial by September. So once the I-140 is approved, you can even file extension of the H1. If the extension is filed before September, you can automatically continue working for up to 8 months, 240 days. Okay, so premium processing of I-140 makes all kinds of sense.
Okay.
I have to go on to my next call. I can give you 5 more seconds. Just ask me a quick question, then I have to move.
Okay. Yeah. If they file EAD during the EAD application process, can I continue working up beyond September 35?
The answer is no. Okay. Good luck.
No.
No, sir.
Thank you.
You're welcome. Okay, guys. Sorry, I have to sometimes hurry you along because there are other people waiting. 4 other people waiting. Okay. New Jersey, go ahead, please. New Jersey, you are one of the first callers. Go ahead. New Jersey. You logged in at 12:33 p.m. New Jersey.
Hi. Can you hear me?
I can hear you, ma'am. Go ahead, please.
Hi, Rajiv. I have a couple of questions. Currently, I'm in a H1B.
Okay.
And my I-140 is approved last week.
Okay.
So my husband is on H4 visa, so I'm planning to apply for H4 EAD next week.
Okay.
And I got an offer currently I'm for consulting company. So I got an offer for a university, which is a non-profit.
Okay.
And they're willing to sponsor my H1 and green card. So if I take that offer, will it be a new H1 completely, or will it be my H1 transfer to the university?
Why does it matter? Because even though it's a transfer, it really it's a matter of semantics. It's really not substantively. There's no difference. So, what exactly are you concerned about?
I was being said that since it's a non-profit organization, the H1 would be a different H1, like a non-profit H1, something like that.
Well,
so I'm not aware of what's the difference between
no difference.
My current H1.
I don't see any difference between in your situation. I don't see how it affects you or your husband if you go from a quota to a non-quota H1. I don't see any problem.
Okay. So for my husband, the other thing is like if I start the EAD process next week and then I change my job and move to the university, will it affect his process, like the EAD process?
The law says as long as there is one I-140 for you that has not been revoked, he will get his H4 EAD.
Okay, so if it's not revoked, then he gets his approval till my H1 end date. So after that, how do I extend his EAD?
You cannot. Not unless you have another I-140 approved. Unless you have another.
So I should have an approved I-140 with the university if I have to extend his EAD, right?
You have to have one I-140 approved through any employer.
I already have my I-140.
Well, if they don't revoke it, that can still be used to extend his H4 EAD.
Okay, until unless it's not revoked.
Yes.
Okay.
All
yeah,
right.
got it. Thank you so much.
Oh, you're welcome. Good luck.
Thanks.
You're welcome. Oh, what do I do with this? All right. All right, folks. 3 more questions left, folks. So let's go to the next one. This one is from Richmond, Virginia. Go ahead, please.
Yeah, I had a quick question about H1B, actually the cap exempt. How long does the process take from start to finish, like change of status from H4 to H1B?
Ma'am,
exempt.
That question is subject to so many variations. I could give you a meaningless time frame, but a lot depends upon premium or non-premium. So it could be 3-4 weeks to 6-8-10 months. It all depends. If you go for premium processing, you increase your chances. I'm
It's
sorry?
not premium, I know that.
If it's non-premium, it could be many months. If they send an RFE, it will take more time. If they send another RFE, then how long do you take to respond to the RFE? Too many variables. Okay?
Oh,
Could be many months.
oh. How many months?
Many months. I don't know how many.
Oh, many months.
Yes. So premium it. You can premium a pending case. Why don't you premium it?
So how long will the premium take?
A few weeks. How many weeks? I don't know. Too many
Oh.
variables.
I don't know if there's a provision of me paying for premium if
Yeah,
the
you
company
can.
is supposed to mention it.
I think you can. I think when the premium is being done for your convenience and your preference, I think it's okay for you to pay. You can tell the employer, I'll pay.
Okay, this is H4 to H1B again, right?
Yeah, no problem.
Okay.
All right. Good luck.
All right.
Bye-bye.
All right.
Okay. This one is from, I can't tell, New York. New York, go ahead, please. New York.
Yeah, Rajiv, this is Siva Vallinayakam. Can you hear me now?
Oh, yes, sir, I can.
Yeah, on the April 5th, 2016, I got my citizenship. I have a quick clarification with you. My first name has a 19 character. The immigration system, it allows only 18 characters to print my certificate,
Okay.
citizenship certificate.
That's a
Is
long.
there any way can
Yes.
I have my 19 characters to print in my citizenship certificate before I go for a OCA?
I don't see how. I mean, this is a, you know how, if you're an IT guy, you know how databases are. Once you have set the format for a field, I don't see how an exception can be made without changing the entire table. Right? So I don't think that you can. That would be my guess.
Okay. And what would you suggest? Can I go ahead with missing last letter? It should not be a problem when I go for OCA.
It's a, see, on the US side, it's no issue. The question you're asking me deals with the Indian side. So I don't really know how India would deal with it. My guess, sir, is that this is a known problem. Everybody knows there's an issue. Okay. So if you run into any difficulties, call back in. We'll figure out what is the best way to go. Okay.
Okay.
Good luck.
Yeah, thank you.
You're welcome. And we come to the last question for the day. This is from also from New York. New York, go ahead, please.
Yeah. So I am Aditya Rathore. I had a question related to H1B.
Ji.
So I wanted to ask a follow-up question. So is it better to go back to India and then transfer to a different company and then come back for an H1B transfer, or filing for B1, B2 here and then transferring to H1B?
Oh, okay. Oh, so you were talking about getting laid off and then filing a B1, B2, and then getting back to H1. Aditya ji, it all depends upon the timing. Don't worry so much. This can be figured out. You talk with your lawyers. What I gave you is kind of a patch. It's not a hugely excellent arrangement. It's a patch that prevents you from being out of status right away. And it also gives you some time to talk to people, arrange for another job. And once that is arranged, then your lawyers can help you decide. The way I would handle it, I would apply for change of status and I would tell them, look, guys, this was extraordinary circumstances. Give us an H1 right here. And if they don't, just send you to either Canada or Mexico and try to get you a visa there. Okay? So don't worry too much about it. It can be handled.
Okay, thank you.
Oh, you're welcome. Good luck, sir. Folks, my pleasure. As always, I really enjoy talking with you. I wish I had more hours in my day and we could have lengthier conversations. But thank you for being here, and I will speak with you folks again in 2 weeks. I think we have a call scheduled. Yeah, there's no interruption in our schedule. See you folks then. Bye bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.